All right, I'm back. I am back. The dogs are fed. What is it? Hold on, let me turn on another light. I hate not being downstairs with all my stuff. Oh, God. Sorry, guys. I'm like in the ghetto over here, I guess. I guess that's a little bit better, right? I think so. I think we're doing pretty good. Guys, don't mind my mess. I went to Sandy Neck today too. Drove the Jeep out on the beach. Got my sticker for the summer. Can't wait. Yeah, I wanted to start off, and I'm gonna rant because these fucking creators, they call themselves creators, but what do? They don't have any actual content. They don't put work into what they do. It's petty streams. It's this thing keeps getting fucking stuck on the rug. It's petty streams. It's just give me a second. Fucking shit show. I swear. I'll get this right one of these days, I promise. This is, Portuguese don't normally go do this kind of stuff. Can you find any Portuguese that are doing this? Because I'm not. I gotta fix my mop. I'm not. I haven't found any. So this should be fun. I just hope I start getting subscribers. Rando, you told me they're gonna start trickling in. I'm still at 7. Don't lie to me, Rando supporter. I have to wear these because it blocks out the noise from just everything. So I have drunk neighbors and they go outside and they sit there. I think they're listening to me, but they sit there and they get hammered and they fight. Let me tell you, I'm gonna tape it. It's like the best thing ever. I don't believe in people getting hammered like that, but man, when you're listening to it and you're not part of it, it's fucking awesome. It's wicked awesome to listen to. Guys, I'm a fucking hot mess. What's going on here? I should have just freaking went live when I got my shit together, huh? Fucking. Here goes. All right. So, yeah, I talked a little shit. The puppy that I have, I've been having a little bit of a hard time with him. My sister comes over today and brings 2 bones. I got 3 dogs. I think I said that already, but don't ask. All right. So we left off on alleged violation, 4th Amendment. Jen agreed with the cops. Okay. So we have here Maybe I should put it over here. That would make more sense, wouldn't it? So then that way I can look at one of these days I'll get this shit straight. Okay. So here we go. So we left off here. This is Jen's appeal. So we began with Bannon's appeal from the district court's holding, entering summary judgment on the merits of the Section 1983 MCRA, assault and battery and wrongful death claims based on the officer's alleged use of excessive force. Both the Section 1983 and like this. I feel like I'm not looking at the screen. Like, what the fuck? So, both the Section 83 and the Fourth Amendment, which prohibits unreasonable seizures, U.S. Constitution, see Graham versus Connor. Bannon does not dispute that as a matter of Massachusetts law, if the officers use force was reasonable for Fourth Amendment purposes, her assault and battery and wrongful fucking hate this. Bannon does not dispute that as a matter of Massachusetts law, if the officer's use of force was reasonable for Fourth Amendment purposes, her assault and battery and wrongful death claims fail. That's fucking bullshit. Let me see. We conclude that no reasonable jury could conclude that they use conclude twice in one sentence. That's whack. Could conclude that the officers engaged in excessive force in violation of the Fourth Amendment for the reasons stated in Part A below, which is a claim that first, let me finish reading that and then we'll go, because it goes on to the next page. We independently hold that the officers are entitled to qualified immunity as described in Part B below. A claim that law enforcement officers used excessive force to effect a seizure is governed by the Fourth Amendment's. I got to put this over here so I don't want to get confused. I have everything in order. All right. So they're claiming the reasonableness standard. And they're citing Graham and Plumhoff versus Rickard. And I looked up those cases and they don't compare to Juston's case at all. I got to make sure people can see the poor face, because I got a poor face today. Poor face. The question is whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting them without regard to their underlying intent or motivation. There's a legal benchmark that's used to judge whether a person's actions or decisions were appropriate and prudent under the circumstances. In other words, was it did that person kill someone? Did they rob a bank? Or what have you? It has to be appropriate. There has to be a good reason behind it, and it's a legal benchmark. Let me see. The fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. The inquiry requires analyzing the totality of the circumstances. They cite Plumhoff. Again, has nothing to do with this case. It's not, doesn't even compare. So to refer to it is bullshit. The inquiry requires analyzing the totality of the circumstances. We consider whether a reasonable officer on the scene could believe that the suspect posed an immediate threat to police officers or civilians. They didn't care. They just opened fire. They didn't take cover. They please, that's a joke. Let me see, where did I leave off? Okay, the defendants do not dispute that the officers seized route for Fourth Amendment purposes. How can you seize a person? During each of the instances and allegedly excessive force, the Brookline shooting, there was two sites. There was the Brookline and the Boston, I believe, the crime scenes. And the Norfolk County District Attorney's Office took over the Brookline scene, investigating it because I guess it falls into their jurisdiction. This inquiry requires analyzing the totality of the circumstances. We consider whether a reasonable officer on the scene could believe that the suspect posed an immediate threat to police officers or civilians. I think I already said that. That the defendants do not dispute that the officers seized route for Fourth Amendment purposes during each of the instances of alleged excessive force. The Brookline shooting, the kick, and the pit maneuver. Okay. All right. Let's back up a second here. The defendants do not dispute that the officers seized route for Fourth Amendment purposes. How about detain? How can you seize a person? Okay? And we pay these people. Do you understand me? We pay these motherfuckers. Let me see if I can move this more like this, and then it can be better, or this way. So then I can read it like this. There were cops that were like yelling the entire time. I mean, there was like probably 5 or 6 of them, and he was probably confused. He probably had no fucking clue what was going on. Let me see. Let me start the sentence from here. Posed an immediate threat to officers or civilians. And then it just says, am I going 29:30? Yep. Whether a warning was given before the use of force, and whether the suspect complied with this command. Can you guys see that? Because it's like blah. Okay, good. You can. Whether the suspect was armed at the time of the encounter or whether the officers believed the suspect to be armed. They're citing the city and city of SF versus Sheehan. It makes no fucking sense. 575 US 606. That's bullshit. Hold on. Sorry, guys. I gotta just highlight this. Citing, I gotta look that. I missed that one. Huh. Okay. The speed with which officers had to respond to unfolding events, both in terms of the overall confrontation and the decision to employ force. Whether the suspect was advancing on the officers, he was on the fucking ground. How could he advance on officers? You know, he was on the ground. Let me see. Whether the suspect was armed at the time of the encounter or whether the officers believed the suspect to be armed. The speed with which officers had to respond to unfolding events, both in terms of the overall confrontation and the decision to employ force. Whether the suspect was advancing on the officers or otherwise escalating the situation. The suspect's physical proximity to the officers at the time of the use of force, such as whether the individual was within range to seriously injure the officers at the time they fired, whether multiple officers simultaneously reached the conclusion that a use of force was required, the nature of the underlying crime. He didn't do anything wrong. I mean, all he did was they know him. They knew him. They knew how he was. He got treatment there. Like his doctor was there. I mean, it's not like he was unfamiliar to them. And like they never, like I said, they never took cover or nothing. And we held that officers were entitled to qualified immunity because objectively reasonable officers in their position would not have understood their actions to violate the law. In so holding, we concluded that each of them factors thought to be relevant. In the case law concerning the reasonableness of officers' use of force, weighed in favor of the officers. In other words, that saying it was okay to shoot Juston 31 times. Like this story, this case never ever ceases to make me sick. It feels like weird. Like, why are these I don't fucking know. I really don't care. Each of these 8 factors weighs in favor of the officer's use of force. No reasonable jury could conclude that a reasonable officer would not have determined that Root posed an immediate threat. That's fucking bullshit. The record makes clear that any reasonable officer would have concluded that Root posed an immediate threat to both to the officers and to the public before and at the time of the fatal split-second decision by 6 officers to shoot Root. The first factor above thus weighs in favor of the officers. The test is not, as the dissent puts it, whether Root posed an immediate threat to police officers or civilians. Instead, the correct test is whether a reasonable officer on the scene could believe he did so. Holding use of deadly force objectively reasonable in part, no reasonable jury, again, the reasonable jury. No reasonable jury could conclude that it was unreasonable for officers to believe that the driver posed an immediate threat. Each of the officers reasonably believed that Root was armed with a gun. Now, there was a whatever, I don't know, foot, what is it called? Those stupid numbers on the side, the footnotes. Fuck they are. I better pick that up before my dog eats it. The hell did it go? I didn't want my dog to eat that chip. So each of these 8 factors weighs in favor of the officer's use of force. The record makes clear that any reasonable officer would have concluded that Root posed an immediate threat both to the officers and to the public before and at the time of the fatal split-second decisions by 6 officers to shoot him. The first factor above thus weighs in favor of the officers. The test is not, as the dissent puts it, whether Root posed an immediate threat to police officers or civilians. I fucking read that twice. Fuck it. Instead, the correct test is whether a reasonable officer on the scene could believe he did so. Holding use of deadly force objectively could conclude that it was unreasonable for an officer to believe that the driver posed an immediate threat. Each of the officers reasonably believed that Root was armed with a gun. The officers also, before I do that, the dissent agrees, factors 2, 3, and 7 and 8 above, respectively, the warnings given, the suspect's armed status, a simultaneous conclusion that the use of force was required, and the nature of the underlying crime clearly weigh in favor of the officers. The others do as well for the reasons explained below. The officers also had every reason to believe that Root posed a continued and immediate threat to them and the public. Officer Golden had witnessed Root fire his gun at him at BWH. He witnessed Root fire his gun at BWH. That's bullshit. It was Golden. It was Golden's gun. I mean, fuck, Juston had a fucking BB gun, dude. Just moments before the shooting, Root had led the officers in a car chase through an urban area at high speeds, ignoring the officers' attempts to pull him over, acting with complete disregard for the officer's safety or the safety of anybody else that might have been on the street and causing a serious collision. No, the collision was caused when Officer Golden performed the pit maneuver. Let's get that straight. Let's see. And throughout, where the fuck's my coffee? Let me see. And throughout, let's see. Root did not comply with lawful orders meant to defuse the situation and eliminate the danger that he posed. Dude, he was on the fucking ground. What kind of a danger did he pose? These included commands to drop his weapon at BWH, to stop and show his hands following the pit maneuver, and to show his hands immediately before the shooting in Brookline. The dissent seeks to separate the shooting in Brookline from the context of the morning's events, arguing the officers' justification for the use of force had ceased before they arrived at the scene in Brookline. Nothing in our precedent supports this attempt to subtract from the analysis the officer's observation of Root's apparent willingness to use deadly force and his disregard for public safety, given his choice to lead officers on a high-speed chase through rush hour traffic, all of which had occurred just minutes before. Indeed, the dissent's position is inconsistent with the circuit's case law. So he crashed because he was hit with the cruiser. He did not hit a cruiser. Like, that's bullshit. All right, I'm not used to reading the stuff out loud. I'm so used to just like, skimming it and going through. Maybe I should like go through and like just pick out what is like really important, and then I have his entire share file that's got thousands and thousands of paperwork. What is it? This sentence. All right. Indeed, the dissent's position is inconsistent with the circuit's case law that is comparatively generous to officers facing potential danger, emergency conditions, or other exigent circumstances. And black letter Supreme Court law holding that we must consider the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. And they cite Graham. Even setting aside the events at BWH, officers reasonably believed that Root was armed and fleeing in close proximity both to the officers and to members of the public driving on Route 9, such as the doctor, or present in that parking lot, such as blank. Anyone within firing range is in proximity to the life-threatening danger potentially created by a gun. Explaining that force is more likely to be reasonable when officers are in close proximity to the suspect. They were in close proximity, and he wasn't moving, dude. He was on the fucking ground. Like, he was not moving. You know what I mean? Like, they tried to make Juston seem like he's this bad person. My hair looks fine. Like, he was this crazy person, and that he shot the guy at BWH. Like, it's crazy. We reject Bannon's argument that it was the officers, not Root, who created this situation by closing in on Root's position rather than seeking cover behind their cruisers, creating a perimeter, or delaying in order to assess the situation. A use of force expert retained by Bannon opined that the choice to follow Root into the mulched area did not comply with standard police practices. As the case law makes clear in situations such as this, that opinion entirely misses the point of the legal test. The Supreme Court intends to surround the police who make these on the spot choices in dangerous situations with a fairly wide zone of protection in close cases, and a jury does not automatically get to second guess these life and death decisions. Even though the plaintiff has expert and plausible claim that the situation could better have been handled differently. Concluding that officer's decision to pursue a suspect into a wooded area rather than create a perimeter, as would have been a standard practice according to the plaintiff's policing expert, did not render the officer's subsequent use of force unreasonable. That's got to change. That has to change. These cops, I mean, they can't get away with this. You know what I mean? Like, this is crazy. Video footage shows the incident unfolding in a public place between Route 9, on which a steady stream of traffic was moving, and a shopping center parking lot. A reasonable officer would conclude that Root, known to be armed with a gun, would endanger the officers and nearby members of the public if not quickly apprehended. Officers encountering suspect in public area had good reason to effect the intended arrest with alacrity, whatever the fuck that means. They're trying to sound smart or something. I don't fucking know. This is bothering me. Like, this is really bothering me. The puppy's in his crate, so I can, like, breathe a little bit. This is my weed. Shit. Better not touch my weed. Better not touch my weed, I said. Don't touch that weed. Oh my God. I'm a fucking hot mess over here. Oops. My lips are like so fucking dry. Don't mind me. I'm just doing what I'm doing. And you guys are just along for the ride. Well, I hope somebody is along for the ride. I need subscribers. I feel like I'm talking. I am talking to myself. Bannon's appeal in the end comes down to an argument that the officers and an independent witness did not see what they consistently testify to and say that they saw. Just before each of the officers made the decision to fire, Root appeared to reach for a gun in his jacket. He didn't. He had his left hand, his right hand on his chest, and his left hand was dangling beside him. Witnesses say that. They testified that and say that they saw that just before each of the officers made the decision to fire, Root appeared to reach for a gun in his jacket. That movement, under the undisputed circumstances, would lead reasonable officers to conclude that Root posed an immediate threat to the safety of both the officers and the nearby public. Holding that officers reasonably employed deadly force where apparently armed suspect made a movement uniformly described by these on the scene as being similar to that of drawing a gun. The fuck does that mean? 5 of the officers gave evidence that each independently saw Root reach into his jacket as if to reach for a gun, despite commands to show his hands, drop the gun, etc. In the seconds before the shooting. The 3 officers who could recall which hand Root used agreed it was with his right. The other individual defendant, Officer Thomas, testified that hold on, there's a footnote here. The dissent argues from the lack of video footage, from what it refers to as the essential time period, that this means summary judgment was entered in error. This argument ignores the fact that on the evidence of record, the officers and an independent witness all gave consistent testimony, and that this testimony is also entirely consistent with the video footage that is available from immediately before and after the shooting. The mere fact that a body camera lens was blocked by an officer's shooting stance at the precise moment officers shot at Root does not, given those other consistent sources of evidence, create a triable issue of fact. The other individual defendant, Officer Thomas, testified that while he could not see Root's hands, Root's movements were abrupt and aggressive. What? What? Abrupt and aggressive, rather than surrendering. He was fucking shot and on the ground. That is exactly what the independent witness saw. Dr. Blank witness statement taken just 6 days, 6 days after the shooting is entirely consistent with and reinforces the officer's testimony. He told investigators that just prior to the shooting, Root turned around facing the officers, and that with his right hand, he put it under his coat, at which time the officers fired. And the doctor's statement that Root turned reinforces the officer's testimony that Root was moving just before the shooting. Yeah, he was on the ground. Bannon offers 2 arguments concerning Root's reach. First, Bannon argues, as does the dissent, that there is a triable issue of fact as to whether the reach occurred. Second, Bannon argues that even if Root was reaching, other facts still render the officer's use of force unreasonable. We reject both arguments. Here, 6, there's a footnote. Let me read that before I start the other one. Bannon argues that we may not consider Dr. Blank's statement because he was not deposed and his statements are hearsay. These objections are meritless and are made for the first time on appeal and waived. See DeRosa versus Hartford Life and Accident Insurance Company. Finding waiver where party failed to object to material submitted in support of summary judgment. Bannon chose not to depose Dr. Blank. Further, she does not argue that Dr. Blank did not witness the events at issue. I believe he's a doctor at BWH, so he's probably bond paid for. Here, 6 different officers from 2 different law enforcement agencies have offered consistent evidence supported by independent eyewitness statements. As a result, Bannon bears the burden of producing contrary evidence and not just hypothetical disputes. She's never had hypothetical disputes. The party opposing summary judgment in a deadly force case must point to evidence, whether direct or circumstantial, that creates a genuine issue of material fact. None of the evidence, Bannon argues, from contradicts the officers and Dr. Blank's description of Root's hand movement towards the inside of the jacket. Bannon and the dissent argue that a reasonable jury could conclude that Root was unable to act threateningly during the essential time period. We see no such evidence in the record. Bannon relies heavily on Blank's testimony that Root kept his right hand at his chest and his left arm at his side throughout the time she observed him, that she did not believe he would be able to stand, and that he appeared to have the lights on but no one home. Whether Blank's testimony nor any other evidence supports a reasonable inference that Root, after Blank observed him, could not have reached his right hand under his jacket. Blank's testimony as to the time when she observed Root is consistent with the officer's testimony that they saw him later reaching that hand into his jacket. Even were Blank's testimony at her deposition based on a few seconds of observation that Root would have been unable to stand, admissible, it does not contradict the officer's testimony that they saw him reaching into his jacket. Indeed, video of the incident shows Root moving from his vehicle to the mulched area under his own power just seconds before she saw him. Nor are the testimonies of all of the witnesses to the shooting called into question by Bannon's medical expert opinion that Root's injuries and blood loss would have rendered him physically and mentally impaired. Nor would impairment mean it was possible for him to move his arm. No reasonable jury could conclude, contrary to the witness statements, that Root was unable to move his arm. Nor does that expert's opinion that Root's gun would have shown visible blood or damage had it been in his hand at the time of the shooting. It calls into question the reasonableness of any of the officers' conclusions from their observations that Root was reaching inside his jacket for what observations that Root was reaching. Conclusions. What? That doesn't make any sense. For what they believe to be a weapon. As a fallback position, Bannon asserts that even if Root did reach, the officer still could not reasonably have concluded that he posed an immediate threat. This position is untenable. The officers did not know the details of Root's medical condition. And Bannon's own expert stopped short of any opinion that Root was so incapacitated as to be unable to reach for a gun, point it, or pull a trigger. Nor were Root's actions or an attempt to comply with officers' commands to show his hands, as Bannon posits. Multiple officers explicitly stated that Root moved his hand into his jacket, a movement inconsistent with showing his hands. We easily reject Bannon's and the dissent's next argument that the self-serving officer's testimony means they are not entitled to summary judgment. This is not circuit law, and the record does not support the contention. I'm speechless. I've read this already, but it's been a while, because it's been a lot. And sometimes you forget what you read. The purported inconsistencies Bannon and the dissent point to do not go to the issue of whether Root reached for his gun. The cases that Bannon cites involving physically or mentally impaired individuals whom courts concluded were not immediate threats are readily distinguishable. See Woodcock v. City of Bowling Green. Holding force unconstitutional where officers shot a man who had not threatened officers or anyone present, made non-threatening movements, and was 70 feet away from officers. Palmer versus Johns. Holding force unconstitutional where officer did not reasonably believe suspect was armed or engaged in any serious crime, and suspect was not acting aggressively. Holding force unconstitutional where suspect was not engaged in serious crime and was not injured on the ground, motionless and armed only with a knife pinned under his body. McKinney versus Mangino. Holding use of force unconstitutional where suspect did not point firearm at anyone or threaten officers, was moving slowly and 69 feet away. Given that the officers arrived at different times, had different vantage points, and had taken only seconds to assess the scene under chaotic circumstances, these minor differences in testimony are perfectly consistent. Beyond that, the officers testified consistently under oath concerning the reach. That reach seen by a reasonable officer would lead the officer to conclude that Root, known to be armed, presented an immediate threat, whether he was seen as struggling to get up or not. Not just one officer gave this account, but every officer at the scene. This argument also ignores disinterested sources of evidence consistent with the officer's statements. Bannon does not contend that Dr. Blank's corroborating statements could conceivably have been coordinated with the officers, and body-worn camera footage from the day shows Trooper Conley recovering the BB gun from the area of Root's chest and hands moments after shots were fired. The uncontroverted and disinterested evidence shows that any reasonable officer would believe that Root was armed, that such weapons were concealed in his jacket, particularly given that he had flashed a weapon earlier in the day by opening his jacket. And 3, that Root reached into his into that jacket. Hang on. Jesus Christ, I feel like I need some fucking light. Okay. So let me see. This argument also ignores corroborated data. No material dispute of fact emerges from the officers having spoken together after the very tense event, putting them in danger before speaking to investigators. Even doing so violated BPD rules. We add that a gun was recovered from the area of his body near Root where Root's hands had been reaching just seconds before officers fired. Now remember, they rolled him over and found it under him. Keep that in mind. As this court has often held, A party cannot survive summary judgment simply by asserting that a jury might disbelieve the moving party's evidence. I need my other camera. As this court is often held, a party cannot survive summary judgment simply by asserting that a jury might disbelieve the moving party's evidence. The non-moving party, Bannon, must instead present sufficient affirmative evidence of its own to create material issues of fact. Holding, where two defendant police officers' testimony was consistent as to key point, that testimony could support summary judgment despite the fact that officers were not disinterested in the result. The dissent suggests that where an officer kills the sole other witness, the officer's testimony is inherently not credible and cites Flight versus District of Columbia. Flight does not stand for that proposition in the DC Circuit, nor is that the circuit's law. Moreover, Flight is entirely consistent with circuit law and easily distinguishable of the facts. There, the testimony of a sole officer as to the individual he shot conflicted with that of every other witness who saw the event and conflicted with the physical evidence which supported the other witness's testimony, creating a material issue of fact. Now, this doesn't have to do with Juston. This was referring to the Flight case versus District of Columbia. Okay, let me see. Despite the fact that officers were not disinterested in result, in short, we see nothing inherently unbelievable about the officer's testimony. 6 officers operating under tense, uncertain, and rapid evolving circumstances. All made identical and simultaneous split-second judgments that deadly force was necessary to protect themselves and the nearby public from rout. No reasonable juror could conclude that all 6 of those officers unanimously, independently, and simultaneously reached an unreasonable conclusion. All 6 of those, no reasonable jury could conclude that the other factors weigh against the officers. The remaining factors, the speed with which officers had to respond to unfolding events, both in terms of the overall confrontation and the decision to employ force. Now, footnote 22. The record does not support the dissent's view. The officers gave conflicting testimony as to whether Officer McMenemy kicked Root to the ground, and that Trooper Conley testified that he saw Root's gun in his hand, which in the dissent's view is impossible given the lack of visible blood on Root's gun. This argument fails to account for the varying arrival times and vantage point of the officers at the time of the shooting. The dissent also cites Goodwin versus City of Painesville for the proposition that Officer Godin's failure to activate his body-worn camera could weigh against his credibility. This is not the rule of this circuit. It is also an opposite. In Goodwin, there was evidence that the officer had a pattern of avoiding documentation of his actions and had already been warned about his failure to use a recording and had already been warned about his failure to turn on his device during a citizen encounter. Here, there is no evidence that Officer Godin had a habit of failing to activate his body-worn camera. To the contrary, Officer Godin had made 2 recordings with that camera. Okay, let me see. Where will we stop? We can stop. Okay, maybe we'll stop here, and then we'll finish. Okay. Sorry, I'm getting tired. Whether the suspect was advancing on the officers or otherwise escalating the situation, and the suspect's physical proximity to the officers at the time of the use of force, such as whether the individual was within range to seriously injure the officers at the time they fired, also favors the officers. It was Root who escalated the threat when he reached for a gun concealed in his jacket. That's what the Commonwealth is saying. Holden's suspect, he was escalating whatever. He waved it back and forth. That's bullshit. And I mean, it's obvious by the lack of blood on the BB gun. The BB gun was clear. Furthermore, Root had just led the officers on a dangerous car chase, stopping only when he caused the collision that disabled his vehicle. Throughout his interactions with police, he had repeatedly failed to obey lawful commands, and rather than giving any affirmative indication of surrender, he instead moved his arm in a way that officers perceived to be a reach for a gun. Noting that an officer had no idea how a suspect was going to behave while he was cornered and not required to take the suspect's apparent surrender at face value, a split second after the suspect stopped running. Okay, we'll stop there because Diana is tired. It's been a long day. I did a lot. I went to Sandy Neck and just drove my Jeep like 17 miles of beach. Fucking gorgeous. Like, that's where I go when I need peace of mind, and I sit here and I look at these people with their Amazon wish list, and I'm not speaking on everybody. I'm speaking on a certain someone. And he states that he has the money to buy like all the stuff that he needs, right? So we have like homeless veterans. We have people that can't even eat. We have people that have nothing. And here he is bragging about all of this shit. Like, I could never. I have too much pride. Even if someone begged me to do it, I wouldn't do it. Like, if I bought a $600,000 house, you bet your fucking ass I'm hooking that shit up. Hooking it up. I don't understand what's going on these days. And, I've been angry at some of these creators because they haven't covered this case. Like, I gave JFK and Jay Brill like all the information, and I thought that they would at least like say something about it. Nope. I gave to one other person and nothing. Melanie Little mentioned it once. She never said nothing about it. No one's talking about it, but I will. I will be talking about it. And I don't know if my life is going to be in danger because of the people that I'm calling out. But as taxpayers, we need to know what the officers are doing. We need to know if they're violating our citizens. We need to know. And in the past, people have been afraid to come forward and say stuff and talk. But it's okay. I mean, you can come forward. I think we're starting to drain the swamps. And I hope that Maura Healey gets booted. Commissioner Cox, he's got to go. Mayor Wu, she's got to go. We need change. We need a new governor. Like nothing's going to change. They allow these criminals to just, run free out of jail. Like that officer O'Malley, when he shot that guy had just left court, I guess. Yeah, what did he have? 16 charges or something? And he took a woman's car. And I don't know, I didn't watch the video, but regardless, I blame Maura Healey. She allows it. She's anti-police. She doesn't care about our officers. She doesn't care about our police officers. She's got to go. We need someone that cares about our police officers, our good ones, and hold the bad ones accountable. And I think that the rot is deep. It's all family. They're all related. It's all like one big. It's deep. It's deep. And, something's up with Sergeant Good. I'm not going to say it because I'm not getting in trouble for, talking out of turn because my name isn't Turtlehead. There's a lot that I know that's going on. And I can say this. Karen will not be getting charged. Will not. No. Her best bet is going after Turtle Boy for recording her. And sever herself from him. Because he thinks, the team is back together. He thinks it's all good. And the fundraiser, he's got it. It says quick Karen Reed, but it goes directly to his bank account. He's been robbing her. When are people going to hold him accountable? He's gross. He makes me fucking sick. I see right through him. And Tim Bradle, how can you represent him and treat Meredith the way you did and represent Kelsey? I think that was a bad move on your part. Turtle Boy should have just fucking left the shit alone and just let Meredith do what she had to do. And he could have just shut the fuck up and he would have been fine. But no. And then Jessica, he created a fucking monster with her. Man, she don't shut the fuck up. She just doesn't know how to shut the fuck up. I mean, Rat House Media, we got the Galera. Where's Ray from Dallas? Nurse Kim. Who else? They're all Sparkly Rabbit now. Like, I refuse to kiss anyone's ass to make it. I'll make it. I'll bust my ass. I'll pump out friggin' content. Someday it will pay off. Well, I hope you guys like it, like my streams. And if you do, please like it, subscribe, help me get on the map because I need to get these stories out. Yeah, my name is Diana. I'm the one that Turtle Boy said was crazy, deranged. I was on JFK, and I was also on Twisted Tragedies. Yeah, they think I'm crazy, but I don't give a fuck. It pissed me off, I'm crazy, but it's whatever. I'm doing this. Something told me to do it. Something deep inside me said, Diana, you got to do this. I'm doing it. And I'm not just I'm Sean Jenkins' case. That one is deep. The Jason Davis. I want to cover Richard Allen. I know that's very iffy, but I believe he's innocent. And this is my channel and I can talk about whatever I want. And if people come on here and you don't like it, I don't give a fuck. Talk shit all you want. I won't block you. Fucking, you don't bother me. Nothing you say bothers me. Troll up. Do whatever you got to do. Have fun. Just make sure you like it. Have a good night, guys. Bye, Rando. Love you.